Case number 112841, State of Kansas v. Pablo Alberto Gonzalez.
Good morning. May it please the Court. Carol Longenecker-Schmidt representing Mr. Gonzalez. Mr. Chief Justice, I would like 3 minutes for rebuttal.
3 minutes is granted.
Thank you. Just to offer a very brief factual description, this is an appeal of a jury trial conviction for unintentional but reckless second-degree murder. The conviction stems from an incident that occurred on New Year's Eve 2014 where Mr. Gonzalez accidentally shot his friend. On appeal, Mr. Gonzalez argued several issues. One about the constitutionality of the second-degree murder statute, a sufficiency issue, and some issues about the district court's answering of a jury question. The Court of Appeals found error in how the district court handled the answering of the jury question, but that error was harmless. Mr. Gonzalez filed a petition for review, and that brings us to this point today. This case is all about the difference between unintentional reckless second-degree murder and reckless involuntary manslaughter. Unless your honors direct me otherwise, I'd like to focus on the fourth issue in the brief, the issue that the Court of Appeals found error with, and that error was the denial of Mr. Gonzalez's right to be present at every critical stage of his trial, specifically during the discussion about the jury's written question about the differences between second-degree murder and reckless involuntary manslaughter. There is a pending motion before this court that the state filed, a motion to remand for recreation of the record. Mr. Hodgkinson filed a response, and so we just incorporate those arguments here. But the main argument is that the state had the chance to petition the Court of Appeals finding that there was error and did not do that. So here today, we are assuming there's error and only focusing on harmlessness. The Court of Appeals specifically found that because there's no record about any of the conversations about the question, that we have to assume that it was conducted outside of the presence of Mr. Gonzalez. Mr. Gonzalez argues that this was harmless for 4 reasons, and those are the 4 factors that both of the briefs discuss. First, the first factor when thinking about harmlessness, which is the state's burden, but the first factor is to look at whether there was an objection. Here, there was no objection. However, there's no indication in the record that the defense attorney even knew about the question. The question was not apparently filed in the district court. It somehow made it into the record on appeal, but we don't have any information that would have given the defense attorney knowledge about this question and an opportunity to object. The strength of the case is the second factor. Although there may be sufficient evidence, which we argue there is not, the state's case was not strong in this case. The state's evidence was not strong in this case. The ability of a post-trial motion to fix the problem. Here the question is the ability of a post-trial motion, which necessarily, I guess, asks, did anyone pursue it? But here, I don't think that even if counsel had pursued a post-trial motion, that it could have fixed the problem, because our argument is that, in part, is that the answer given to the jury was also incorrect. A post-trial motion in this situation would have been, I think, a motion for a new trial, which is essentially also what we're asking for here. So this is different than a situation where you could file a post-trial motion and bring jurors in and ask, was the question read to you exactly how it was written on the paper? That's an important question in this case, but more important, even if the question or the answer, was read exactly how it was written, we argue that the response was incorrect. So substantively, the answer was incorrect.
No, I'm confused. The answer was go look at the instructions.
Yes. So that weaves back to the third issue in the brief, which was that answer was not a meaningful answer. That answer should have.
It's not incorrect. That's what I'm jumping on, I guess. Here is, as I understood your argument, it is that since the jury has asked a question, they deserve an answer. They already had the instructions in front of them. So that's the way I got it, that it was inadequate because they'd asked a question and you only told them what they already knew. Am I missing something?
Yes. So
Okay.
the answer should have been, or as I read it in the brief, should have been quoting some language from Robinson, essentially. So the jury was presented with two possibilities, two different crimes, and they were having trouble distinguishing between the two. And Robinson provides clarification on what this court has said, at least in the past, is the difference between those two offenses. And instead, the district court did not give a meaningful answer, just referred the jury to the instructions, which didn't help them clarify the difference between the two offenses.
Okay, so make the argument that if that had happened, the verdict would have been different. 'Cause to me, I see those factors, and I was thinking about this last night. I see those factors. A lot of it really just falls by the wayside. What we need to know is whether this made a difference. And so, given your theory of what should have happened, why does that matter?
This gets a little tricky because it leads back to our first issue, wherein we argue that there really is no difference between the two statutes. And if that's true, then it's actually impossible to explain to the jury the distinction between these two crimes. So I think providing the answer articulated in Robinson would have helped the jury get to a different result.
And that result then would have been involuntary manslaughter.
Yes.
Because you're saying the elements of the offense are identical.
That is essentially what we're saying. They are identical.
And that's different than being unconstitutionally vague. That's where I had difficulty with you, because it's not vague just because two statutes have the same elements.
I think they are can be taken differently. I think when two statutes have the same elements, one of those statutes, in this case, second-degree murder, necessarily has to be vague because so the legislature has split these out into two different elements: reckless and then under circumstances manifesting extreme indifference. And as a person of the public, if you're looking at that and you see, well, there's two different elements, they must mean different things, but they're defined as the same thing, that is confusing. I don't know how to gauge my behavior. I don't know how to define that extreme recklessness if there's two elements, but they both mean the same thing. So yes, we are arguing that they are identical, and I don't think it affects the constitutionality of the reckless and voluntary manslaughter statute. But here, because the legislature lists them out as separate elements, but they define the same thing, it makes it unclear. And even if this court finds that it is not so vague as to render the statute unconstitutional, at the very least, the jury needed some clarification about the degree of recklessness that was required to convict under second-degree murder. I think that's particularly important because of the, I think it was 2013, the amendment to the culpable mental states that redefined recklessness. So Robinson was interpreting the statutes under the old definition of recklessness that just required a realization of the imminence of danger. Now, recklessness is defined as being aware that a certain result, death, will follow, and then consciously disregarding that risk. If you are aware that death will follow and you disregard that, you necessarily have an indifference to the value of human life. And so that's the argument that the two statutes actually prohibit the same conduct, or at the very least, it's confusing, as the jury was confused in this case, and the court has an obligation to clarify the degree of recklessness. I'll just briefly touch on Johnson versus U.S. and then wrap up. I think the only point that has not been discussed, that I have not mentioned about why the second-degree murder statute is unconstitutional, is the United States Supreme Court's 2015 holding in Johnson v. U.S. That case is a different context, one about sentencing under a residual federal sentencing statute. But I do think it opens the door for a broader vagueness analysis for this court. I think what Johnson stands for is the proposition that for a person to imagine an ordinary crime, in this case, an ordinary reckless killing, and then to have to imagine a higher level of recklessness, to go beyond that, that is too vague, that does not...
Explain that to me, because I don't see that as the mechanical process that the instructions are directing the jury to do. I understand it in Johnson, I think, because there's a judge is having to imagine a different crime. The jury is always being told to take the facts as they unfolded at the trial. Those are real facts. That's not an imaginary anything. And to apply those facts to two different descriptions of two different crimes. I mean, I don't want to argue about identical offenses. But the jury is always told to use the facts as they have determined them from the evidence at trial. So they're not imagining anything. But that's the difference I see between what's happening here and what you're talking about in Johnson. So where am I wrong?
The distinction, I think, is that, so here, when we're looking at a vagueness analysis, it can be helpful to look at it through the perspective of a jury reviewing facts at trial. But we're also talking about, generally, does the statute provide sufficient warning for people, or does it invite arbitrary enforcement? And so you can take it out of the context of this trial and think about other applications. And when a person is reviewing their conduct, they're required to imagine an ordinary reckless killing, that the level of recklessness that's ordinarily involved in all killings.
I don't see any imagining happening. That's where I'm jumping off on you on. I don't see where the jury is supposed to figure out some. They're not even trying to figure out what a reasonable person would necessarily do. Here are the facts, put them against this standard and this standard.
And I think my argument is that I'm not talking about the jury and the facts in this case. I'm talking about a person out in the world being aware of whether his or her conduct constitutes second-degree unintentional, right?
The
crime.
The first prong of the two-prong test that's talked about.
Right.
Okay.
You're talking about the notice requirement, basically.
Mm-hmm.
Yes, I am. Yeah, and so that person is not evaluating. I mean, they're in the moment of their actions, but they're not evaluating some sort of other set of facts. They are required in that moment to imagine an ordinary reckless killing, and then does their conduct go to this higher level of recklessness?
And what should any person think when they put a gun to someone's head and pull the trigger?
That is reckless conduct, and that there is a risk that will result in the death of the person you are pointing that gun at.
And that's not manifesting extreme indifference to the value of human life?
Two answers. No, because he previously pointed the gun at his own head. But more importantly, because he immediately drove to the police seeking help. And
that's the unintentional part of it, I think, isn't it? I mean, if you're intending to shoot him, then maybe you let him lie there. But if you didn't intend to shoot him, then you call 911 or you go get help.
But I
you're
think
horrified by the results of your recklessness.
Yeah, but that would show that you do value human life. That's my understanding. I mean, there are examples of depraved heart, second-degree murder, where you hit a person on the head intentionally, and that person's unconscious, and then you just walk away. Clearly, there you're not valuing that human life. If you know that person's going to die and you don't do anything, you just let it go. Yeah, how,
But there are differences there in factual scenarios, and I think what they're trying to, the New Year's Eve, you run outside with your weapon and you start shooting in the air, and someone, versus putting up against someone's head and pulling the trigger. They're both maybe unintentional, but one of them is more egregious, wouldn't you say?
sure,
And so I think this is intended to, it might be a bit nuanced, but it still sets degrees of crime. And we have that in other areas, that degrees are based on culpability. And I agree, most people wouldn't be able to understand most of our legal jumbo, but that doesn't make it unconstitutionally vague just because it's in legal language, but it does set up two different levels of culpability, doesn't it? I mean, you keep saying they're the same thing, but don't you see the factual scenario that's different? And I guess what I need to know is why don't these definitions make that distinction?
yeah, my answer to that is, again, I'm going to rely on the statutory language and say that the definition of recklessness also describes an extreme indifference to the value of human life. I think there certainly are various factual scenarios that would show various levels of recklessness. Johnson talks about the fact that you can find a statute
Now,
vague.
You said the definition of recklessness includes extreme indifference.
Not literally, does not include those words.
Right.
But our argument is that if you are aware that your actions will cause death and you do it anyway, that therefore you have an indifference to human life. So the meaning of the words, that means the same thing. In Johnson, the United States Supreme Court said that there are ways you can find a statute void for vagueness, even if some applications it's not void. It doesn't have to be void in all applications, or vague, in all applications. Even if this court, I understand that it could be a stretch to find the statute void, but at the very least, the statutory amendment blurs the line and makes it confusing. And here, the district court did not help the jury in distinguishing between those two offenses. Also did not, also violated Mr. Gonzalez's right to be present during the discussion. And the state has the burden here to show beyond a reasonable doubt that that did not contribute to the verdict. And so with that, I would just respectfully request that this court reverse Mr. Gonzalez's conviction.
I have a couple questions, if I can, on an issue that I don't think we've talked about yet, and I'll try to make this quick. And I think it's issue 4, where you say the district court erred by failing to answer the jury question in open court. Your argument there is that that's a Sixth Amendment violation, right?
Yes.
And so if we have a statute that permits the district court to do this in writing, you don't care about that because you're saying it's a constitutional violation, right?
Yes.
And is the specific Sixth Amendment violation you're alleging the failure of a public trial, or is it the failure of the defendant to be present at all critical stages, or is it both?
It is, as briefed, I understand it to be both.
Okay.
That they were, yeah.
So you did preserve and argue that it was a Sixth Amendment violation to fail to answer the jury question in open court because it denied your client his right to be present at that critical stage.
That, I'd have to review that.
Okay.
I'm not sure if it was a violation just to be absent during the discussion about the question, or if
Those are
if it was
two
briefed.
issues, at least as I understand it.
Sure.
Issue 3 is presence during the discussion, and issue 4 is the answering of the question, or
Presence.
failure to answer in open court.
Sure.
Presence when the written answer was just given to the jury.
I do not recall if presence during the answer, if that was briefed and preserved, or if it was just, if that part, the answer was just argued as a violation of the
Okay.
right to a public trial. I can review the brief and
Okay,
try
thank
to
you.
submit a helpful answer.
Any more questions? Thank you, counsel.
Good afternoon. May it please the court, the appellee state of Kansas appears by Stephen Obermeyer. I'm a assistant solicitor general.
You just couldn't stay away from us, could you?
I could not. I was at home watching Rockford Files, and my wife gave me a two-prong test. Find a hobby that gets you out of the house. And so here I am. And I'll argue issues 1, 3, and 4 in that order. As to issue 1, does the statute sufficiently give a warning to the defendant that when you point a gun at somebody's neck, when you're 3 times the legal limit, 0.25 BAC, 3 hours later, not sure whether the gun is loaded and you pull the trigger, whether you don't understand that that might manifest extreme indifference to the value of human life by your conduct? Do I not understand, how can you not understand that?
But I don't think that's, well, maybe that is the argument, but I thought the argument was, how would you not also understand that was conduct done under circumstances that show a realization of the imminence of danger to the person of another and a conscious and unjustifiable disregard of that danger. And I think it's where you split that hair between those two, and how you distinguish the legalese of extreme indifference to the value of human life and the conscious and unjustified disregard of the danger to the person of another.
I think you split it by, as the court did in State versus Cordray and State versus Robinson, by saying if your conduct is reckless, that's involuntary manslaughter by disregard, substantial and unjustifiable risk that deviates from the standard of care, gross deviation from the standard of care. But on top of that, if that recklessness is under circumstances manifesting extreme indifference to human life, then that elevates it from the involuntary manslaughter to the reckless second-degree homicide. And I think that's what the court has said in Cordray and Robinson. And I think the U.S. versus
That's an argument of how we split the hair, but I think the argument, how does ordinary citizens split that hair and know, which conduct is prohibited in what manner? Or is it enough to know it's prohibited conduct and the degree will fall where it falls?
I think it's probably just the latter, that what you do there is showing extreme indifference to human life.
The notice prong of the vagueness analysis is really just a legal fiction, isn't it? Because people don't walk around saying, I might do that if it's only involuntary manslaughter, but if it's intentional second degree, I'm not going there. I mean, that's just not the way we operate, right? We just live and we do good things and bad things, and then later on, all of us figure out how to classify it and what to charge and what to prosecute and what you get convicted of. It's a theory. If a reasonable, ordinary person looked at it and was aware of it, then could they tell the difference? It's not whether they walk around knowing the difference, is it?
Correct. I doubt that Mr. Gonzalez researched the difference before he...
Most people who commit
Year's
these crimes
Eve.
do not spend a lot of time splitting the hair my colleagues identified.
Right.
Not in advance.
I-
So
I-
warning is a fiction, a legal fiction we engage in to make sure that the statute's not vague.
Well, as I understand it, that there has to be sufficient warning that by doing this,
Right.
that it makes it vague. And the second part is that it guards against arbitrary enforcement, and we have the presumption that it's constitutional. So,
That's okay. I think I already
okay,
wiped
all right.
it on enough.
There's some language in the Johnson case that the Court of Appeals cited distinguishing Johnson from this case. In Johnson, the court said at page 2557 that the residual clause language ties the judicial assessment of risk to a judicially imagined ordinary case of a crime, not to real-world facts or statutory elements. And here we have statutory elements that make it a difference, and that is the under circumstances manifesting extreme indifference. Which leads us to the third issue, whether Judge Elder's answer was an abuse of discretion in not helping the jury answer the question. And the state's contention is that it was a legally correct answer to the question, can you provide more clarification of the differences between murder in the second degree committed unintentionally and the involuntary manslaughter? So it sounds like they have clarification. They're just asking for more clarification, or at least one juror is asking for more clarification. I mean, sometimes I think we think it's a 12-0 vote on what makes a jury question, and I don't think that's always the case. So we have the district court judge who can look at State versus Robinson or Cordray, which has language saying a jury is expected to decipher many difficult phrases without receiving specific definitions such as the term reasonable doubt. That's from Robinson. And Cordray, where the same question by the jury, and the judge referred the jury back to the instructions. And keep in mind that, the judges don't have, this jury trial was in August of 2014. They don't have 3 years and a few months to decide how we're going to answer this question. They've got a jury over there waiting. And so the judge answered, please refer to the instructions provided to you. And in the appellant's brief, they came up with a proposed answer 12 months after the fact, and when their brief was filed, which basically is a repetition of the jury instructions 10 and 11. It's just a restatement of jury instructions 10 and 11. And so I think it was an adequate answer by the judge, and a reasonable person would take the position adopted by the district court in doing that. Which brings us to this next issue, the improper conducting of discussions about the jury's question off the records and outside the presence of Mr. Gonzalez. And to get to this question, we make a lot of assumptions that that number one, that the judge isn't familiar with what the law is, that you bring in the defendant and the attorney when you have a question. We don't assume that the defendant's present, whether there's a discussion with counsel, whether it was held outside the public's purview. We're making all these assumptions and kind of making it a negative assessment to the judge. The judge doesn't know what he's doing. That he just went rogue and just answered this question on his own and didn't let anybody know. And so that's one of the reasons that I asked that if you do consider some sort of reversibility inquiry like you did in the Horton case, I think it was, that let's at least have some sort of hearing on what actually happened. And you can tell by the transcript that the judge was aware that had talked with counsel during the course of the trial. In chambers, at page 352, there had been an in-chambers conversation that the defendant's witness wasn't going to be here till 1:30 in the afternoon. And so they continued it till the afternoon.
Well, in Horton, we didn't remand it back to clarify what happened. in Horton, what occurred, as I recall, was that there was a motion brought by defense counsel after the jury began its deliberations. And Judge Davis said, boy, I wish I could consider that, but once deliberations start, I can't do anything. And then on appeal, we determined that that was an abuse of discretion. Yes, we have case law that allows you to, in limited circumstances, to reopen the case. We sent it back for Judge Davis to consider, and I recall it was a transcript that was from a strange dialect from South American country or something, so it took some time to get what that was. But the point was that we found that there was an abuse of discretion. Go back and reevaluate it once you get that evidence as to whether you had allowed the jury to hear this evidence. That's different than what you're asking for. You're asking us to kind of recreate what happened, and I think there's a real difference here.
Well, you didn't.
It would be pretty rare that we would take the road. It was pretty rare we took the road there, but it's
Right.
anytime there's an absence in the record, we would just send it back to recreate what happened. I mean,
Well,
that's different. That's different. There's not an absence in the record.
Right, and usually there's a presumption that the judge acted correctly and knew what the law was, but we don't seem to be doing that. But you're correct as to your recitation as far as Horton, that I don't think there was the transcripts presented to the judge for the reversibility inquiry. I was just saying, and looking through the record, that the judge knew that you have these conferences with defense counsel. For example, at page 397, volume 7, the judge, it's a close of trial on Wednesday, close of evidence, and the judge says, I can email jury instructions to you. I've got the verdict forms, so we can go back to my chambers and we can go through some of that, okay? And the prosecutor says, and you want to do that now, Judge? And the death penalty defender attorney, Mr. Gonzalez's attorney, says, I don't require Pablo's presence. Fine, you remain in custody. So the judge knows that there's this rule about having the defendant present for things like discussing jury instructions. And there's several references, like in volume 7, page 396, of discussing things in chambers. Same thing in volume 8 at 404 at the jury instruction conference. There'd been an informal conference about jury instructions, and then on the record, the defense attorney explains why he thinks there should be a voluntary instruction, or voluntary intoxication instruction. So that attorney knows how to make a record by objecting to things. And so here we have the question, can you give us more clarification on that? If there's no disagreement that you should refer back to the instructions, I guess there would not be a record on that. But
Let me ask you about what happened
that.
next,
Okay.
which is the answer.
Yes.
Are you contending that the defendant was present when the answer was given to the jury?
The record isn't, well, if it were remanded, I think it would be something that would sure make a difference.
The record doesn't say.
The record doesn't say.
At first blush, we would presume that he wasn't present, but that's also a different procedural stage, and I'm just wondering if you would make the same kinds of arguments like typical process would have been for the defendant to be present. Would it? I mean, are you saying that typically when the judge sends a written response back, he would have called everyone into open court and had the defendant present to do that?
I think it probably varies with the judge, and I don't know.
Well, presume with me that the defendant was not present
Okay.
when that answer was given to the jury.
Okay.
Why isn't that constitutional error?
Well, if he's not present and that's a critical stage, and defense counsel can't waive his presence like he did waiving the defendant's presence on the last day of evidence, it would be...
Well, we have a case, we have precedent, State v. King, 2013 case,
Right.
where we held that a court answering a question to a jury by written response violates the Sixth Amendment if it's not done in open court with the defendant present. That's what State v. King says. we have a statute that says the judge can send the answer back in writing. I'm
Correct.
exploring the potential tension between those. Do you have a
Okay.
position on that?
My position is that there's no claim that the statute's unconstitutional. I'm not sure there's a U.S. Supreme Court case that says that it's a critical stage of the proceedings for the defendant to be present during a legal question or a question that the jury has. And in my 609 letter, I cited a sublet case out of the state of Washington, kind of talking about whether that's an issue. But here the statute says the judge shall respond to all questions in writing or in open court. And so in writing would be appropriate. And since that answer is filed and somehow it got into the record on appeal here, that would not violate the Sixth Amendment right, I think would be my answer.
We were just
to that
wrong
question.
when we said that it did in State v. King. That's your position.
Well, I don't like to say that.
Well,
Certainly, I think the primary issue in King was it violated the statute, which had been amended in 2014 and was in effect at the time of this trial in August of 2014. So I think that's what I would respond. And if it is a Sixth Amendment right, then you get to the whether or not it's harmless error, and for the reasons set forth in the Coyote type of line of cases, it was an innocuous answer referring the jury back to the jury instructions, and that there was not a reversible error in that answer given. State versus Reed, and I'm not sure when Reed came out in context of King, probably after, says the public trial right attaches to those hearings whose subject matter involves the values.
right, but that gets to the question I was asking your opposing counsel, and I don't need to belabor it, but there's a difference between a public trial right and a right to be present. And the outcome might be different depending on which right we're talking about.
Correct. And here again, we don't have a record that knows what right we're talking about. I mean, back when I was a trial attorney, some of these things would be done in chambers, and if the press wanted to be back there, they could. Some of them were done in open court, and so I think that's a little bit different issue. But I think just the issue of we're just going to presume from a silent record. I cited State versus Jones, or State versus Jones is mentioned in the brief, and that was a case where the court reporter did not put in there that the defendant was present on that issue, and the defendant was present, and it got reversed for that for a new trial because the judge's answer was incorrect, and I just think that's something more to consider on a 1507 after the fact, instead of we're going to just go from a silent record, draw inferences against the trial judge, and presume the defendant wasn't there, and just presume error. But I know that Betts is against me on that issue, and the law seems to be. But even with what the judge did with that process, that it was as harmless error if you get to that issue. I think that's all that I had as far as my presentation.
Do we have any further questions? Thank you, counsel.
Thank you.
Just briefly, in regard to Justice Deagle's question about the constitutional right to be present and what has been preserved. I think in the brief, both presence during deliberations or discussions about the question and during the delivery or reading of the question, I think both of those aspects, right to be present, were briefed. As well as public trial, both of those are a public trial. However, the Court of Appeals only focused on absence during the discussion about the answer, and the petition for review only discusses harmlessness. So I'm not sure if this is properly preserved to talk about, let's see, the defendant's constitutional right to be present during the readback, or the tension between the constitutional right and the statute allowing a written answer.
Any further presentation?
No, Your Honor, I would waive the remainder of my rebuttal.
Well, let me ask a question. You've got your brief in front of you. Page 13 is the proposed answer that you have that on page 13 of your brief.
Oh, yeah.
Go,
Okay.
go get
You can go get it if you want.
I got it here.
Okay.
Okay, yes, Your Honor.
As I look through that, the only thing that I see different from what's in the instructions already is the second sentence. Would you agree with me that the second, I'm not sure that it's legally accurate, but I don't want to quibble about that right now. Regardless, the second sentence is really just a transition to tell the jury to look at the next two sentences, right? What is, I'm asking, you're saying that there wasn't a meaningful answer, and I'm trying to figure out what's meaningful in what you proposed.
In this paragraph.
And everything else is in the instructions. But I see the second sentence, which is the one difference, as being introductory, if you will. Because then you're saying, you're looking at different levels of recklessness. The first thing you got to look at is the extreme, and the circumstances that don't value human life, and then you've got the other one. But so do I read the second sentence correctly, do you think? Or is there something substantive in it?
I think that's correct. I think it is a transition sentence. I think the most significant sentence in this paragraph is the third sentence that acknowledges that all reckless killings have some sort of extreme or indifference to the value of human life. And the way you distinguish, arguably under Robinson, is does this killing have an extreme indifference that goes above and beyond that which is inherent in all reckless killings? I think that is still confusing. I don't think that is, I think that shows why the statute is void for vagueness, excuse me. But under this court's current case law in Robinson, I think that was the correct answer. That would have helped the jury determine between the two
And
offenses.
my only thing is, I think that's just instruction 11, subparagraph 1. And so I'm just having difficulty seeing how this helps a jury that's asked a question versus go back and look at the instructions.
Sure. I think another response is that, this court could conclude that perhaps this proposed instruction would not have helped, but maybe there was maybe there is a current better articulation between the two differences, between these two offenses, particularly now that the statute's been amended. And whatever that is, that clarification should have been given to the jury. And so perhaps remand is appropriate to give a new, more clear, more definite description between the two offenses.
Any more questions? I see none. Thank you, counsel. Thank you both for your arguments this morning and this afternoon. Court will take this matter under advisement. That concludes